Okay, imagine this. You're working exactly the way you and your boss agreed you would. You're hitting all your deadlines, you're getting the job done. And then, out of nowhere, you're fired for not showing up. That's the crazy paradox at the heart of this entire story. And that one sentence, that's the whole mess in a nutshell. It captures the total communication breakdown that landed a part-time accountant and her employer in a legal battle. You've got two sides with two completely different ideas about what showing up to work even means. So, let's meet the people involved. On one side, we've got Sophie, the accountant. On the other, the small company that hired her. See, Sophie was absolutely convinced they had a clear, verbal agreement for a flexible schedule. The company, though, well, they saw things very, very differently. And this, right here, lays the conflict bare. Sophie's take was simple. I have another full-time job, so I'll work for you guys on evenings and weekends. But the company was basically saying, whoa, where is she? Her being gone all day is causing chaos. So she saw herself as a dedicated worker burning the midnight oil. They saw her as a no-show. The real problem at the center of it all? Not a single word of their agreement was in writing. So you're probably wondering, how did things get this bad? Well, for almost 9 months, everything seemed to be working just fine. Sophie came in during the evenings, on weekends, used her key, punched in her alarm code, no problem. But then, the company hit some financial trouble. They tried to negotiate an exit with Sophie, but those talks just completely fell apart. And then, right after that, the company changed the office alarm code and just didn't give her the new one. They literally locked her out. And then, they fired her for, you guessed it, not being at work. I mean, from a human perspective, it's just a total mess. You can kind of see how both sides felt they were in the right. But when this thing landed in court, hurt feelings and personal perspectives weren't going to be the deciding factor. The court did not focus on emotion. It asked one key legal question. And that was it. That's the whole thing. The entire case pivoted on this one simple question. Was there ever an official, written-down rule that said when Sophie had to work? The answer was going to decide everything. And that question, it leads us to a really important legal idea. In a dispute like this, it's not actually up to the employee to prove they were fired unfairly. Nope, it's the other way around. The law puts all the responsibility, the burden of proof, squarely on the employer's shoulders. This is what lawyers call the burden of proof. It basically means the company had to prove with cold, hard evidence that Sophie broke a rule that was clearly established. It wasn't enough for them to say, well, she should have known, or, but everyone else works 9 to 5. They needed to be able to point to a specific, written rule about her hours and prove she violated it. And here's how the court just took the company's case apart, piece by piece. First, the company pointed to the contract, saying it mentioned normal work hours. The court shot back, saying legally, that term refers to the length of the work week, those 20 hours, not the specific start and end times. Then the company tried, but all our other employees work 9 to 5. The tribunal called that a logical fallacy. Why? Because Sophie's contract was with her, an individual. What her coworkers did was legally irrelevant to her specific agreement. And finally, when the company complained her schedule was disruptive, the court's response was blunt. It is the employer's job to organize the workflow, period. So the conclusion was just inescapable. The adjudicator found that the company had completely failed in its duty. They never put the work hours in writing. In fact, Sophie's own work history showed a consistent pattern. She had always worked this way. And the final nail in the coffin? The decision actually called the act of changing the alarm code brutal, a move that physically prevented her from working, which created the very absence the company then tried to use to fire her. So with the company's arguments completely dismantled, the verdict was pretty clear. But what came out of it is a much bigger lesson for all of us about the huge danger of unwritten rules at work. The firing was thrown out. The court declared that the company's termination notice had no legal basis. It was completely void. And the consequences for the company were serious. First, they were ordered to give Sophie her job back. Second, they had to pay all of her lost wages for the time she was locked out. And third, and this is the big one, they were now legally required to do what they should have done in the first place. Sit down with Sophie and finally put her work hours in writing. So what's the big takeaway here? For employees, it's simple. A verbal agreement is not a guarantee. If your schedule is important to you, get it in writing. For employers, the lesson is even more stark. The duty to set the rules is on you. You cannot punish an employee for breaking a rule you never officially created. And for all of us, this case is a powerful reminder that an established, consistent practice can, over time, become just as legally binding as any written contract. It really makes you think, doesn't it? We often assume that unwritten rules just give the boss all the flexibility and power. But as this case clearly shows, when things go south, that lack of clarity can leave the company holding all of the risk, which raises a pretty crucial question for every single one of us in our own workplaces. One decision changed everything. Watch the next case right here and subscribe for more real stories.